difference between exemptions and exceptions. Without going too far into it, when Congress drafted the Federal Rules of Evidence, they made a mistake. They basically said, for some ungodly reason which has no actual logical basis whatsoever, we're going to put this lump of things that we think are exceptions to the hearsay rule, and we're going to call them not hearsay. It'll make sense afterwards, but just understand that everything in 801 subsection D technically is an exception. However, it is absolutely improper for you to argue that as an exception, unless you're in the state of Florida, which actually did it correctly. That means that the things in 801 subsection D are exemptions, things that are not hearsay. For some reason, they don't seem to fall under this definition of inadmissible hearsay. So, let's go through them. 801 D1, prior statements by a witness. Now, this was a very colorful little explanation I had for this last week, and unfortunately I won't be able to give you that same explanation this week. There are really three main things that are 802, 801, thank you, 801 D1. Not hearsay. Exemptions.
Something else not say your face there.
What?
Just your not looks like the happy face.
Okay. Marcus, what are the two groups of things that are not hearsay under this rule?
Two groups. Admission by a party opponent.
You're going too broad. Oh, no, you're not. I'm sorry. All right.
And prior statement by witness.
Admissions by a party opponent and, right, prior statements by the witness. Now, without even reading the rule, just looking at the titles, what is the difference between 801 D1 and 801 D2? Anyone? It's in bold. There are 7 words. 801 D1 provides that that prior statements by a witness are not hearsay, whereas 801 D2 provides that admissions by a party opponent are not hearsay. I understand that you guys don't necessarily know what those terms mean yet, but understand that there's a difference between 801 D1, 801 D2, prior statements by a witness, applies to any witness testifying. It's broader. 801 D1 applies specifically to party opponents. And what is a party opponent?
Other way around.
Yeah,
What do you
801 D1 is prior statement by
One is
witness.
the witness.
I don't care about the numbers. You guys need to get the numbers right. But yes, you're right. It is 801 D1 is prior statements, 801 D2 are admissions. What is a party opponent?
People who are bringing the case, or like defending it.
I can't hear you.
The two sides involved in the case, like whoever's name or whatever is on.
The person on the opposite side from you.
It's the purpose.
Well, those
Exactly.
are the party opponents, are both of them.
Not necessarily.
Not in the criminal
Who's the
case.
who's a party? Who is the defendant's party opponent in a criminal
The
case?
state.
State.
No one
You're wrong.
for everyone.
You can't. The state represents the state of Florida, which would mean that taking that definition literally, every citizen in the state of Florida would be this particular defendant's party opponent. Which just goes to show you the irony behind this rule. It's a very harsh rule when it comes to criminal defendants. The purpose, or I guess the effect of allowing statements, admissions by party opponents in a criminal case means that every single thing a criminal defendant says before the trial, unless Miranda and all that stuff applies, but you guys don't have to worry about that, is admissible against him or her, no matter what. No questions asked. It's very important for your case coming up because you guys are going to have a criminal case, which means that practically speaking, anything in anything that the defendant ever said in your entire packet is going to be admissible with just by uttering the words, this is an admission by a party opponent, Your Honor. That's it. Comes in. Wave your magic wand, and it comes in. Under admissions by a party opponent under 801D2, there are, what, 5 different kinds of admissions. It's A through E. Someone give me the first one.
Inconsistent with the declarant's testimony and was given under oath subject.
No, 801D2.
Oh, my bad. The party's own statement in either an individual.
Stop.
Just parties on statement.
Party's own statement. Own statement. What are we talking about there?
Something they actually said.
That defendant, or in a civil case, that plaintiff. I guess I should clarify that. The admission by a party opponent rule applies differently in civil and criminal cases. In a civil case, the defendant can offer the plaintiff's statements as admissions by a party opponent, and in a criminal and the vice versa. However, in a criminal case, the state can offer the defendant's statements as admissions by a party opponent, but you really never have an opportunity to offer the state's statements as admissions by a party opponent because there really is no statements on behalf of the state. Does that make sense?
What about if like an officer was testifying for the state and they made a statement against the defendant? Could you offer that as a statement by the state?
You might be able to get it in under the second clause under subsection A of this rule that says in an individual or representative capacity. It's still walking a fine line, because before that you'd have to show that he was operating as an officer of the state in the course of his employment, and that statement that he made was also in furtherance of his employment. So there's a lot of background that foundation that you'd have to lay in order to get that in, but it might come in. It would be a good argument to make. What's the second one? B. A statement of which a party has manifested an adoption of belief in its truth. Jack. Right? Did you have this one last week?
Which one? I wasn't
No,
here
you
this
weren't
week.
here. Who did I explain this? You? No. Alright, well, whatever. A statement where the party has manifested adoption and belief in its truth. Alright, Meg, remember how I said, is it hearsay if someone asks you a question and you nod your head?
Mm-hmm.
Change the facts. If I ask you if that chair's pink and you say yes, is that hearsay?
Yes,
Now, applying this rule,
it's an exemption
why?
because
Assume for a moment that you're not actually a defendant or a plaintiff. You're not involved in the suit.
it's an adoption. It's something that the party opponent has adopted, like an agreement that they made, or not an agreement that they made, but an agreement that they entered into.
I wouldn't use the word agreement, but yeah, that's basically it. Basically, when you respond affirmatively to someone's question, you're adopting a belief in the truth of that question. So, think about it like cross-examination. Marco, that chair is pink, right?
Yes.
Alright, you just assented to the fact that at least you agree that the chair is pink. So you've adopted and manifested a belief in the truth of my statement that the chair is pink. What that means is that quite literally, in court, we can essentially say that Marco said the chair is pink, even though the words never came out of Marco's mouth. Does that make sense? Actually, what this rule does is allow you to put words in someone's mouth. C. A statement made by a person authorized. So these are authorized statements. Someone that was here last week, tell me what they are. What that means. While I write this stuff on the board. Anyone?
If statements made by someone, a party opponent who's authorized to make those statements. It's like someone who isn't them, but they're authorized to speak on their behalf.
Such as what?
Like, the vice president of a company speaking to a company, something like that.
Press conferences.
That's a good example. Press conferences, being like a representative of a company would really fall under this, under the fourth one. So hold on, let's just,
Okay.
let me get there. What's the second part of this though, this whole authorized statement? Read the rule.
Statement concerning the subject.
Right. It has to be concerning the subject that they were given authority to speak upon. So, if, like using that press agent example, if Rex were my agent and I authorized him to go out and hold a press conference on my behalf and only speak to my good character, when in reality I'm actually on trial for murder. Rex would not be authorized by me to speak about any bad character traits that I had, but he would be permitted to speak to any good character traits that I had. So anything that he said that was about my good character would be considered not hearsay, but anything that he said about my bad character would likely be considered inadmissible hearsay. You see the distinction there?
I didn't know it could be twisted like that.
Well, I mean,
Because using that example, the CEO or some managerial person could be like, oh, well, he wasn't authorized to say that.
under that subsection,
Uh-huh.
it could be twisted like that. But the counter argument would be, well, Your Honor, there was no limitation on the subject matter. I mean, there are a lot of ways you can go with that. But understanding it just narrowly in that subject, in that scenario, using that particular subsection, there is a limitation on the subject matter. Now, the fourth one is an agent or servant. Statement by the agent or servant concerning a matter within the scope of the agency.
Using our example, would this be a good go-around between the unauthorized statements? Saying I was giving a press conference, you authorized me to speak to your good character, I badmouthed you. You tell them that that wasn't authorized, but I was acting within the scope of my employment or agency.
Yeah, that would be a good way to flip it.
Okay.
That would be a good way to flip it. I mean, the better way to understand this particular part of this particular admission by a party opponent is in the context of a CEO of a corporation. And the CEO holds a press release himself on behalf of the corporation. Say the corporation is on trial for some sort of white-collar fraud or something like that. And he gets up there and he says, while it may be true that there were some individuals at our corporation that in some way defrauded our stockholders, it in no way permeated the rest of the corporation. We are still, we're still soluble in the whole 9 yards. That entire statement can be admissible under this rule because he made that statement as the CEO of a corporation. And the argument that you'd have to make in order to get that hearsay evidence in under this rule would be something to the effect of, Your Honor, Mr. So-and-so was making this statement in representative capacity of the corporation. He was acting within the scope of his employment when he got in front of the public and he held a public press conference for all to hear. He made these statements for the benefit of the corporation. He was acting in the scope of his employment within his agency, which basically, I mean, that's it. That's your argument. So understand that each one of these rules each one of these subsections really has two subparts, and it might be hard to see, but keep in mind, like here you have, it has to be the party, and it has to be their own. It has to be an adoption in the truth. It has to be an authorized statement concerning the subject matter. It has to be an agent or servant within the scope of agency. So there are really two parts that you have to prove or establish, or argue at least, in order to get inadmissible hearsay evidence in under these rules. The last one is co-conspirators. What's a co-conspirator?
Somebody who aided in the crime.
Right.